All right, where would you all like to start today, South Annex?
Yes, Your Honor, good afternoon. Before you is position 2, Ms. Bell.
Good afternoon, Ms. Bell. Who's representing Ms. Bell this afternoon?
I am, Your Honor.
Good afternoon, Ms. Gant.
Good afternoon, Your Honor.
Good afternoon, Ms. Bell. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good afternoon.
Yes or no?
Yes.
Yes.
Okay.
Yes.
You've been charged in case 22 CR 001246J with simple battery family violence. Is there a history pretrial? Howard?
First arrest.
Mr. Segura, good afternoon.
Good afternoon. The incident occurred on the 6/28th, 2021 at 3301 North Camp Creek Parkway, Southwest Dearborn, Atlanta. And this situation also was responding to the scene. And the incident occurred was when Stephanie Bell, Stephanie spelled STEPHANIE, Bell, common spelling, went to pick up her son's check from her grandmother's house. There was an argument between the defendant and her. In it, as the argument continued, her daughter, the defendant, attacked her and hit her in the arms and pulled off her wig. As such, the state is recommending a $2,500 surety bond, a stay away from Stephanie Bell's home located at 1890 Myrtle Drive, Southwest Atlanta. No further contact with Stephanie Bell, and no alcohol, drugs, and weapons. So based on recommendations on these facts, and also concerned that the victim in this case was the mother of the defendant, and as such, we are concerned because of the family relationship. As such, these are our recommendations.
Ms. Gant?
Thank you, Your Honor. Ms. Stephania Bell is 18 years old. She is a high school senior. She is a student at Washington High School. She makes mostly A's and B's. Her favorite subject is science. She plans to attend college and has applied to Savannah State, Georgia Tech, and Clayton University. She aspires to be either a nurse or to serve in the National Guard. Your Honor, she is not employed at this time. She does not have the means to pay any bond. She denies the allegations. She states that she was merely acting in self-defense as her mother, Ms. Stephanie Bell, came to the residence at which Ms. Stephania Bell resides, which is her grandmother's address, Miss Betty Wilson. She states that her mother came there basically being disruptive, and she basically was defending herself, and she states that her mother initiated physical contact. Your Honor, my client does not have any prior convictions. In fact, Ms. Bell was unaware of this warrant. She and her mother have resumed relations. However, I was unable to contact Ms. Stephanie Bell. We are unopposed to the stay away and the no contact order. And also due to Ms. Bell's age, I was able to reach out to her grandmother with whom she has been living since age 14, Ms. Betty Wilson, and she is willing to co-sign a signature bond on Ms. Bell's behalf, Your Honor. And for these reasons, I am requesting a signature bond. Thank you.
Okay. $2,000 signature bond through pretrial. Since no one spoke with Ms. Stephanie Bell, no further contact with Ms. Stephanie Bell. Stay away from the 1890, was it Motor Drive address? No drugs, alcohol, or weapons while out on bond. If she needs a co-signer, that'll be Betty, I guess, Betty Wilson, Wilson.
Correct, Your Honor.
Okay. And I will waive the utility bill, Mr. Howard. Anything further on Ms. Bell?
Nothing further, Your Honor.
All right. Good luck to you, Ms. Bell.
Next, we have position 8, Ms. Forston.
Your Honor, I represent Ms. Forston. However, I just received a message from Ms. Kim. She is requesting to be let, well, I see that she's logging on now.
Okay. All right, so she's logging on, and you represent Miss Forston?
Yes, Your Honor.
Okay, good afternoon, Ms. Forston. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Ms. Forston, you've been charged in case 22 CR 001250A with battery family violence. Is there a history, Mr. Howard?
Oh, first,
Mr. Segura?
The incident occurred on March the 6th, 2022, at the incident location at 3540 North Camp Creek Parkway, Southwest Atlanta. In this case, the victim, Hakeem Woods, Hakem spelled Hakem, Woods, common spelling, was at the back porch grilling when the defendant came to confront him about past infidelities. The dispute became violent, which ended up resulting in the defendant forcibly grabbing Mr. Woods' dreads and forcing him to the ground. While on the ground, the defendant was hitting Mr. Woods, and she placed her weight on his left knee, causing temporary damage. As this fight continued, the defendant also hit Mr. Wood with a stick, causing a laceration on top of his head. The state is recommending a $4,000 surety bond, no alcohol, drugs, and weapons. I stay away from an instant location at 3540 North Camp Creek Parkway Southwest, and no further contact with Hakem Woods. Our recommendation is based on these facts, as well as that the victim, Hakem Woods, is in a relationship with the defendant, and as we can tell, the defendant has a 5-year-old daughter who also lives at the same location, but we are uncertain if the daughter is also the same one with Mr. Woods. But considering the type of relationship the two have, this is our main concern. Thank you.
Has your office spoken with Mr. Woods?
We tried to, but no one responded.
Ms. Gant?
Thank you, Your Honor. Ms. Kiara Forston is 27 years old. She is a long-term Atlanta resident. She has a 5-year-old daughter. She is not receiving child support, and she is the primary caretaker. Your Honor, we are opposed to the stay away at 3540 North Camp Creek Parkway, as that is her residence. She stated to me that while she was being detained, Mr. Hakeem Woods' relatives were removing his belongings from the home. I have also followed up with Marquilla Johnson, who is Ms. Forston's cousin, and she informed me that in fact, Mr. Hakeem Woods was removing his belongings from the home. However, she was unable to confirm whether or not he had retrieved all of his belongings. So, Your Honor, I am requesting that there be no stay away for Ms. Forston, but a one-time law enforcement escort so that Mr. Hakeem Woods may retrieve any belongings that remain. She does not want any further contact with him. And per my understanding, she does not share a child with Mr. Hakeem Woods. More about Ms. Forston. She is a high school graduate. She obtained a forklift certification. She also has certification in medical assisting. She is currently employed at FirstNet. She has been in that position for about 6 months. And Your Honor, given her length of employment and her prior history, I am requesting a signature bond on her behalf. She does not have the means to pay much toward bond. She denies the allegations. She merely states that she was acting in self-defense. She and Mr. Hakeem Woods had been in a relationship for the last 2.5 years. However, she reports that he has been abusive to her in the past. He gets drunk. He attacked her initially, which caused her to have a black eye. She states that she now has bruises and scratches on her person, including a knot on her head. She called the police to get Mr. Woods to leave her property, and she felt in fear of her life. And Your Honor, for these reasons, I am requesting that signature bond for Ms. Forston. Thank you.
Okay, a $2,000 signature bond through pretrial, 1-day anger awareness, no further contact with Hakeem Woods. She can have a police escort, go back to the 3540 North Camp Creek Parkway address. If Mr. Woods is not there, then she's free to stay. If he is there, then she's going to have to make other arrangements and can retrieve her belongings. No drugs, alcohol, or weapons while out on bond.
Thank you.
What did you say? Oh, the bond was?
It's a $2,000 signature bond through pretrial.
Thank you.
And anything further on Ms. Forston?
Nothing further, Your Honor.
All right. Good luck to you, Ms. Forston.
May we be excused, Your Honor?
Yes, we'll see you next time. Thank you.
Thank you, sir.
Okay, who do we have? Are we going to courtroom 3?
Courtroom 3, position 7, Dennis.
Good afternoon, Ms. Dennis. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, good afternoon, Your Honor.
Thank you, Ms. Dennis. You have been charged in case 22 CR 001249J with simple battery. Is there a history, Mr. Howard?
First.
Mr. Segura?
The incident occurred on March the 7th, 2022 at 850 Oak Street, Southwest Atlanta. In this situation, victim Patrice Anderson, Patrice spelled P-A-T-R-I-C-E, Anderson, common spelling, was in the mall parking lot of the incident location. She crossed paths with the defendant. The defendant, without any provocation, dropped her bag, followed, and approached Ms. Anderson and then attacked her. The defendant punched Anderson in the face with a closed fist several times and also snatched off her wig from Mr. Anderson's head. In this situation, the defendant thought Anderson started a fight, and there was also a witness who saw this. Because of this, the state is recommending a $4,000 surety bond, a no further contact with Patrice Anderson, 1-day anger awareness, no alcohol, drugs, and weapons, and MHET, mostly due to the facts of this case, as well as due to some situations relating to the victim. The victim, Patrice Anderson, and the defendant have been both living together in the same homeless shelter in the past, and Ms. Anderson has noted that the defendant was constantly harassing her for weeks while at the shelter. Also, making known that the defendant actually has 2 open warrants against her for battery, substantial physical harm from March 28, 2016, and a cruelty to children on the same date. And also would like to make it known that Patrice Anderson is on Zoom. That is all, Your Honor.
Thank you. Ms. Gant?
Thank you, Your Honor. Ms. Rashida Dennis is 22 years old. She has been a lifelong Atlanta resident. She states that she does not have any family here. She states that her family members are currently residing in Jamaica and Africa. She has 2 children, a 4-year-old son and an 8-year-old daughter. She's not receiving child support, and she is the primary caretaker. Your Honor, she completed the 11th grade and she's now working on her GED. She is a server at Sweet Auburn. She has been in that position for about 2 weeks. Therefore, she does not really have the means to pay much to a bond. She denies having any prior criminal history other than an arrest in 2017 for trespassing, Your Honor. And she states that she is on probation for traffic or driving offense. A driving offense. So that history is foreign to us. She denies the allegation. She does in fact recall having some dealings with Ms. Anderson. However, she states that when they met at that parking lot at 850 Oak Street Southwest, Ms. Anderson advanced toward her in a threatening manner as if she was about to attack her. So she was more so defending herself, Your Honor. I am unopposed to the no contact order as she does not want any contact whatsoever with Ms. Anderson. I am opposed to the MHET. There are no concerns whatsoever regarding my client's competency, and I do not believe that the state has put forth any sufficient basis to warrant such an order. And again, for these reasons, I am requesting a signature bond, Your Honor. She is recommended, and if Your Honor determines that she is ineligible, then the lowest bond possible. Thank you.
Okay, thank you, Ms. Gant. I see I believe it's Ms. Anderson on Galaxy A12. Is that right? Okay, I can't hear you, Ms. Anderson.
She's gonna have to go out and come back in. She's not connected to the auto. She's only connected to video.
Okay, did you hear that, Ms. Anderson? You're gonna have to leave the Zoom meeting and come back in. because you're not connected to the audio for us to hear you. All right, so let's see. While we're waiting for that, courtroom 3, can we go to someone else?
Yes, we can go to Jessica Griffith. I think it's position 11.
Thank you. Good afternoon, Ms. Griffin. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video today?
Yes.
Thank you. Ms. Griffin, you've been charged in case 22 CR 001253F with battery, family violence, and cruelty to children in the 3rd degree. Is there a history, Mr. Howard? If you're talking, you're on mute.
Yeah, I was. 3rd arrest. Last was December 2020, battery, family violence out of Clayton County. March 2020, battery, cruelty in the 3rd, Clayton County. She has a hold out of Jonesboro. FTA warrant.
Okay, thank you. Good afternoon, Ms. Falk.
Good afternoon, Your Honor. This incident happened March 7th of 2022. It was around 1:28 p.m. and the incident location is 3160 Desert Drive, apartment 8. That's going to be in East Point. Officers responded to a fight call, and when they arrived, JW, who is a 10-year-old juvenile male and is the subject of the cruelty to children in the 3rd degree, answered the door. In the background, the officers could hear 2 women yelling and cursing. And Your Honor, I just do want to point out that this case is a cross warrant case where we have Ms. Sagu, and I may be saying her name incorrectly, who is on our calendar at position 25, just for Your Honor's information. When they arrived, they could hear the 2 women yelling. They had both women step out. They spoke with both of them. They have been living together for approximately 1.5 years and have broken up on the day of this incident. Ms. Sagu stated she had placed the defendant's belongings on the porch. And when the defendant came to pick up her items, she actually came into the residence instead of picking them up from the porch. Ms. Sagu stated she was unaware that she was coming in. And at that point, a fight ensued when Ms. Sagu tried to have the defendant leave the residence. At that point, the officers then talked to the defendant. The defendant claimed that Ms. Sagu actually pulled her out by her hair, and she was attempting to defend herself. Officers did see marks and bruises on Ms. Sagu, and on Ms. Griffin, they saw a bite mark on her left hand, and unable to determine a primary aggressor, they arrested both parties. The juvenile JW did make a statement to police that he heard arguing, and when he came outside, he saw the 2 individuals on the ground fighting with each other. So that's why they arrested both. The state's recommendation on this defendant is going to be a $10,000 surety bond. And here is why the state is making this recommendation. As pretrial has stated, there are 2 pending cases. One is 2020 CR 03658. That is in Clayton County. It has been accused and is currently pending. We have another one, 2021 CR 02771. That has also been accused by Clayton County and is pending. Both were not against this victim. They were against a different victim. However, both were family violence battery, and one was also an added charge of cruelty to children in the 3rd degree. So there is a pattern of behavior that has been established at this point. Additionally, the surety bonds on those cases were $5,000 surety on one charge, a $4,000 surety on the other family violence battery, and then a $2,500 surety on the cruelty to children in the 3rd degree. So she already had a grand total of $11,500 in surety bonds when she bonded out. And as pretrial has accurately stated, she currently has a bench warrant on that 2020 CR 03658 where she has a hold. I know the defense is very fond of saying, well, let her be transferred back to Clayton, but at the same time, we do ask for a surety bond because the whole idea of bond is that we are judging whether somebody is a risk of reoffense and judging whether they will return to court. And I think she has failed on both of those counts at this point, Your Honor. She has shown with two previous exact same family violence battery, exact same pattern of behavior, family violence cases before. We are now on our third open family violence battery case with a cruelty to child element. And additionally, she is bench warranted on one of those cases and needs to answer on those charges for failing to appear back in. They issued the bench warrant January 15th of 2022. So based on all of that information, we are asking for a $10,000 surety, and I believe that it is warranted. Thank you.
Thank you, Ms. Falk. Who represents Ms. Griffin?
Ms. Griffin, I do, Your Honor.
Go ahead, Ms. Kim.
Yes, she is 30 years old and she does not live in 3160 Desert anymore. So she does not have any objection to stay away from that incident location. She just needs one-time visit with a law enforcement officer for her personal belongings that she has put out on the porch. But if there's anything that, she can kind of take those clothings away. And that child, JW, is actually a child of number 25, position number 25, Miss Sogo. So we don't have to have third-party child visitation either. At this point, she has been here for the last 30 years, and she has her family, parents, and 4 sisters in here in Georgia. And she also has a job, and she works as a machine operator. She wants to keep her job, so I don't think it is wise for her. I don't think that she has any flight risk. She graduated from high school, and she also went to Savannah State University up to junior. She studied forensic science and biology. Regarding those previous arrests and failure to appear, even though that happened, this was clearly, she was not a primary aggressor. Thus, we would like to request for signature bond on this. Thank you, Your Honor.
Your Honor, and I did omit the conditions, and my apologies. We are asking for a stay away from 3160 Desert Drive, apartment 8, East Point, Georgia. No further contact with Shakoria Sugu, that is SHACORIA, last name Sugu, SOUGOU, and no alcohol, drugs, or weapons is provided.
Thank you. It's going to be a $4,000 good bond for the battery, a $1,000 good bond for the cruelty, makes a total of a $5,000 good bond. Stay away from the Desert Drive address. She can go back to that address on one occasion with law enforcement to retrieve any belongings that she may have there. No further contact with Ms. Sagu, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Griffin.
Thank you, sir.
Do we have
Position
Mr.
10, Loaded Green.
Is Mr. Grew in the courtroom? Your courtroom?
Oh, yes.
Could we do her next since this is fresh on my mind, please?
Sure, position 25.
Thank you.
Sure.
Good afternoon, Mr. Gu. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged, Mr. Gu, in case 22 CR 001254F with battery, family violence, and cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
No.
Ms. Falk?
Yes, Your Honor, and this is her first arrest. I will go out and say that although the police were not able to determine a primary aggressor, based on the history of Ms. Griffin, we are We are choosing to go forward as far as a surety bond with Miss Griffin, obviously, and are asking for a $5,000 signature bond for Miss Segu. Again, that is based on the fact that she does not have a history, as well as the fact, and that Miss Griffin clearly does have a history of family violence battery, as well as the fact that, according to the police report, it was Miss Griffin who came into Miss Segu's home, because at that point they were separated and living in separate locations, and made contact, even though Miss Segu had placed Miss Griffin's items outside of the home for her to pick up. So based on all of that, we are making a determination at this time, barring any additional evidence, that Miss Griffin was the primary aggressor. We are requesting a $5,000 signature bond, no further contact with Jessica Griffin, no alcohol, drugs, or weapons, and we are going to ask for 1-day anger management.
Okay. Good afternoon, Ms. McLeod.
Your Honor, I
Yes.
represent Ms. Segu.
Yes, good afternoon. Good to see you.
Good afternoon. As
Good to see you.
Councilor has noted, my client does not have a history. She is 30 years old. She has been living in the Atlanta area all of her life. She is the mother of a 10-year-old as well as a 4-year-old. So she has 2 children that she is primarily responsible for their care. She does work, Your Honor. She tells me that she works in a factory. She also has a nonprofit which is involved in feeding the homeless people in Atlanta once per month. Based on her history, Your Honor, I think she should have a signature bond, but I do think $5,000 is somewhat high given her history, her age, and her other circumstances. Also, Your Honor, I believe that the other defendant was a primary aggressor, and I don't think an anger management is necessary for my client. And we would note that it was my client's son that called the police because he was concerned, Your Honor. That was how the police got to the location. My client has expressed that she's really not afraid of the co-defendant. She has told me that. But my client was definitely not the aggressor.
Okay, thank you, Ms. McLeod. For the battery, family violence, is going to be a $2,000 signature bond through pretrial. For the cruelty, a $1,000 signature bond through pretrial. Makes it a $3,000 signature bond through pretrial. 1-day anger awareness class. No further contact with Ms. Griffin, and no drugs, alcohol, or weapons while out on bond.
Thank you.
Good luck to you, Ms. Segu. You're welcome. Courtroom 3, would you mind? Can we go back to Ms. Dennis, position number 7, please?
Yes, sir.
Thank you. Was Ms. Anderson able to join us?
Yes.
Okay.
Yes, sir.
Well, unfortunately, she's on the phone. She can't get on with her auto through her video.
Okay, so I've seen Ms. Anderson on the lines. Can you raise your right hand for me, Ms. Anderson?
Yes.
Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, so this is what I want, Ms. Anderson. I don't want you to tell me anything about what you think about Ms. Dennis's mental health. If you want to tell me what about what you believe is her mental health, I don't want to hear about, but I do want to hear about, if you have anything to tell me about this incident, I'll be happy to hear it from you, okay?
Absolutely, sir. What I wanted the courts to know is that this woman has been harassing me for weeks. We were in the same facility, but I have never said a word to her. She purposely followed me all the way from North Highland to the Mall West End. I was going to Planet Fitness to recover some equipment that I had left there. Had no idea this young lady was coming around the corner. As the witness stated, she came and directly ran and attacked me with no reason, no malice, no issue. I don't know her. And for her to be a total stranger, she has to have mental issues. This was some harassment that was starting from a place where we were both in a place where we needed assistance. I was focusing on going to work. I was on my way to work that morning. And I'm a 54-year-old grandmother, and I'm also a native of Atlanta. My mother, etc. And, we have been pillars in this community. I just happened to get into a situation where I needed help for a couple of weeks. And this young lady and amongst other young ladies decided that they were going to harass me because I did not want to communicate with them, and very well so. And she definitely has an issue to follow and stop people. She does not have custody of any children. I don't know where all this is coming from. I don't even know the young lady's name until today. But I just wanted that to be reinforced. She needs some help. And also I want to make sure that for my safety, because she knows I work at Fulton County and she knows where I get off the train because she's been harassing me all this week. So just to make sure that I can be safe, as I travel to and from work or wherever I decide to travel in the city, we should not run into each other's company, because I'm 54 years old. This young lady is way far younger than I am. I'm a grandmother of 6. I have injuries myself that I could not even have alluded myself to anyone. I don't even fight, and it was just no reason for this to happen, I've never seen this young lady a day in my life, but besides us being residents at this facility. And for her to just try to harass and pursue me, to attack me, is something terribly wrong with her.
Okay, thank you, Ms. Anderson. You're not at 850 Oak Street anymore?
No, sir.
Okay, all right.
No, sir.
Anything further, Ms. Segura or Ms. Gant?
None.
Your Honor, I would just reemphasize the complaining witness's testimony that she does not really know much about my client. She did state some things regarding my client's mental health, which she is not competent to do. Again, I'm opposed to that mental health evaluation, and we of course affirm that this was mutual contact. And again, I am renewing my request for the signature bond, Your Honor. Thank you. And we are, again, unopposed to any contact, which will take care of any concerns regarding reoffending. Thank you.
So I'm going to have her monitored through pretrial. So a $2,000 SOB through pretrial, 1-day anger awareness, no further contact with Ms. Anderson, and no drugs, alcohol, or weapons while out on bond.
All right, thank you, Your Honor.
All right, good luck to you, Ms. Dennis, and you also, Ms. Anderson.
Thank you, Your Honor. Position 10, Mildred Green.
Good afternoon, Ms. Green. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Ms. Green, you've been charged in case 22 CR 001252H for simple battery. Is there a history, Mr. Howard?
Second arrest. No, hold on. The first arrest.
First arrest, okay. Who's on the iPad in the green? Yes, ma'am. If you wouldn't mind, stop eating unless you can share with everybody, okay? All right, thank you. Let's see, Mr. Segura.
The incident occurred on March 7th, 2022 at 175 Piedmont Avenue, Northeast Atlanta. In this situation, the officers arrived at the scene, and it's mostly because the defendant caused physical harm by Mabiti Conte, but Mabiti spelled M-A-B-I-N-T-Y, Conte spelled C-O-N-T-E-H, by striking her. The state is recommending that the court retain a $2,500 surety bond, 1-day anger awareness, and no alcohol, drugs, and weapons. I stay away for the incident location at 175 Piedmont Avenue Northeast, and no further contact with Ms. Conte. Our recommendations are based on these facts, as well as because we are concerned about Ms. Conte's safety as she was hit, after all. Thank you.
Who is Ms. Conte to Ms. Green?
And We're not exactly sure. The police reports we have does not identify what sort of relationship they have.
Okay. Ms. Gant?
Thank you, Your Honor. Ms. Mabinti Conte is a student, a college student at Georgia State, as is my client, and they reside in the same dorm. Your Honor, Ms. Green is 18 years old. She is a long-term Atlanta resident. She has family here. She is attending Georgia State. She is a freshman. She's majoring in business marketing. She makes mostly A's and B's, and she aspires to become self-employed or an entrepreneur. Your Honor, she is also working part-time at CBS while she attends school full-time. We are opposed to the stay away at 175 Piedmont Avenue as that is a dorm. And Ms. Green has a legitimate purpose to be there. Your Honor, instead, we would ask that you order a no violent contact order and to not issue a stay away. She has no prior history whatsoever. Therefore, I am requesting a signature bond. I have been in contact with her mother, Miss Katrina, spelled Katrina, Blackshear, spelled Blacksear, and she is willing to serve as co-signer on a signature bond. Thank you.
All right, so Ms. Green lives in one unit of the housing facility and Ms. Conte lives in another unit?
Yes, Your Honor.
Okay, all right. All right, so it'll be a $2,000 signature bond through pretrial, one-day anger awareness, no further contact with Ms. Conte, but I'm not gonna make her stay away from the dormitory. She can go back to the dormitory, but she cannot have any contact with Ms. Conte or her actual dorm in the 175 Piedmont Avenue dormitories. You'll have to have a co-signer, so that'll, I take it, be Ms. Blackshear.
You want to waive that?
Yes, I will. Do I want to waive?
Since she in college, I mean, that's what I was asking. It's up to you though.
Okay. Okay, so she doesn't have to have a, she won't have to have the co-signer. No drugs, alcohol, or weapons while out on bond. All right, good luck to you, Ms. Green.
All right, thank you, Your Honor.
Next is position 13, Jayla Hampton.
12 and 13.
Thank you.
Thank you.
Good afternoon, Ms. Hampton. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Ms. Hampton, you've been charged in case 22 CR 001255Y with battery substantial physical harm and in case 22 CR 001265Y with theft by taking. Is your history, Mr. Howard?
I got first arrest.
Mr. Segura?
Beginning with the battery case, the incident occurred on April 20th, 2020 at 285 McDaniel Street, Atlanta. In this particular incident, the defendant, after the victim, Kedrivius Merritt, spelled K-E-D-R-A-V-I-O-S, Merritt, spelled M-E-R-R-I-T-T, received an Instagram text. An argument ensued. After that point, the defendant attacked him by assaulting him with a knife and a cell phone. The defendant struck Mr. Merritt in the face with a cell phone, resulting in a bloody nose. And as such, the state is requesting for the battery case, a $6,000 surety bond, no alcohol, drugs, and weapons, no further contact with Mr. Merritt, a stay away from the 585 McDaniel Street, Atlanta, and a one-day anger awareness. We also would like to make it known that aside these facts, we're also recommending this case to DZA's office because the security guard saw the defendant chasing Mr. Merritt with a knife, and thus it could be an aggravated assault. As to the second case about death by taking, that incident occurred on March 7th, 2022 at the Heritage Station Apartments at 765 McDaniel Street, Atlanta. In these particular facts, the defendant and Jasmine Dubois, Jasmine, Jasmine, Debruce, Debruce, were having a verbal dispute about both of them being the girlfriends of Mr. John Giles, John, common spelling, Giles, Giles, and Mrs. Debruce's vehicle. As his argument ensued, the defendant ended up taking a 4L chain, an Apple iPhone, and debit cards belonging to Mr. Giles from the cup holder of Debruce's vehicle. At this point, the defendant went up to her own apartment, carrying all these items, and then had Instagram video showing them off. At this point, Mr. Giles asked for his stuff back, but the request was refused. And in this particular case, Miss Jasmine Aaliyah, Jasmine, Jasmine, Aaliyah, Alia, was a witness to this event. For death by taking, we're requesting that the court retain the $1,000 surety bond, no alcohol, drugs, and weapons, and no further contact with Mr. Giles. In this case, the facts of this case, and because Mr. Giles, who was the victim in this case, has a child with the defendant, and as such, we know that he's in a very unique position. Thank you.
Okay, thank you, Mr. Segura. Ms. McLeod?
Yes, Your Honor. My client has been in an extremely abusive relationship for over 9 years with Mr. Giles since she was a teenager. They actually share 2 children together, an 8-year-old and a 1-year-old. Mr. Giles has been extremely abusive to her, not just physically, but also emotionally. Part of his abuse, his emotional abuse, includes having other women attack her. This happened recently with the person called Jasmine, who is apparently one of his current girlfriends. He had this woman come over and attack my client while my client was pregnant. She lost her child and she just came out of the hospital towards the end of February. She had a miscarriage as a result of that attack. Your Honor, she is actually the victim here. She tells me that she works, she is self-employed, but she's in no position to pay for a bond right now, Your Honor. This is the first time she's been arrested. After extensive discovery with her, she's definitely has been the victim. Mr. Giles, who is alleged to be the party who was the victim, he is actually the person who has been abusing her. As far as the stolen property is concerned, she tells me that this woman called Jasmine called her to say that Mr. Giles would be coming out of jail and that she was going to bring his things over to my client's house. My client agreed. She came over there. They were actually talking, and Miss Jasmine left this stuff with my client. Then she called my client a few days later and said she wanted the stuff back, and my client gave her back the stuff. When the police came, they searched the house. There's none of the stuff there. Jasmine was given the stuff back. My client deserves to have a signature bond, Your Honor, so she can get out and heal. She spent days in the hospital and she really should be at home resting her body right now. Plus, she does have 2 small children that she is primarily responsible for, since Mr. Giles is really not a responsible father. So
Okay.
I would ask the court to consider giving her a signature bond, Your Honor, so she can get out of jail and take care of her children.
And what do you say about the battery substantial physical harm with Mr. Marin?
That was Mr. Giles, Your Honor.
They were both.
That was my understanding that he's the father of her child, and he came to her house with some other woman.
Okay. Okay, so let's go back to position 12. I believe that Mr. Segura told me that it occurred at 285 McDaniel Street with a Cabrazio Merit. Is that correct, Mr. Segura?
It is.
Okay, so is Mr. Cabrazio Merritt somebody different than Mr. John Giles?
I don't know who he is because my client told me it was Mr. Giles, but maybe I misunderstood.
Okay, I think that the theft by taking is with Mr. Giles and the battery substantial physical harm is with Mr. Merritt. I see you there with your hand up, Ms. Hampton. You have a right to remain silent. Anything you say can be used against you. Let Mr. McLeod speak on your behalf right now because I don't want you getting into saying something that might get you into
This Mr. Merritt may have been one of the people. Mr. Giles is in the habit of sending other people to attack her. That's what she has told me. So it could well be that Mr. Merritt was one of these people, Your Honor, and that I misunderstood her. But she did tell me that he has in the past used friends and other women to attack her. And she was hospitalized as a result of one of those attacks just recently in the latter part of February, and she had a miscarriage. She was over 6 months pregnant at the time. And so this is pretty significant, Your Honor. It's not a small thing.
I understand that, and I'm sorry for your loss, Ms. Hampton. I'm trying to understand who lives at 285 McDaniel Street. Ms. Hampton, who?
Ms. Hampton, you can answer. Who lives there?
That's my ex-boyfriend's sister house.
Okay, so you don't have any reason to be there, right?
No, that's old. I didn't even know that property. Yeah.
Okay, and who lives at 765 McDaniel Street?
Me.
You live there?
Yeah.
Okay. And Mr. Giles does not live there with you, does he?
No.
Okay. And does she have any children with Mr. Giles, Ms. McLeod?
Yes, Your Honor, she has 2 children with him.
So she's going to need a third-party transfer?
Yes, Your Honor. Well, the children are not legitimated.
Okay.
I'm just saying, it seems like, you know, he has been pretty abusive to her, Your Honor, and he has not legitimated the children.
Okay, well, I'm just trying to figure out if a father is out there who wants to see the children, or then, you know, if I'm going to issue something against them. I'm just trying to figure out what's going on here. Okay, so anything further, Mr. Segura?
None for me.
All right, so for the battery substantial physical harm, it's going to be a $3,000 signature bond through pretrial, a 1-day anger awareness class, no further contact with Cabrazio Merritt, and stay away from 285 McDaniel Street. No drugs, alcohol, or weapons while out on bond. For the theft by taking, it's going to be a $1,000 signature bond through pretrial. No drugs, alcohol, weapons while out on bond. No further contact with John Giles. And if there is to be any visitation with the children, it's got to be accomplished by a third-party transfer of the children. All right, anything further on Ms. Hampton?
No, sorry.
All right, good luck to you, Ms. Hampton.
Next position
Thank you,
14,
Anna.
Freya Harris.
Good afternoon, Ms. Harris. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Harris, you've been charged in case 22 CR 001256A with battery. Afternoon, Ms. Mitchell.
Afternoon, Your Honor.
Is there a history?
Your Honor.
Oh, I'm sorry, Ms. Mitchell.
Go ahead.
Is there a history, Mr. Howard?
It's an 8th arrest. Last was April 2021. Simple battery against police. Misdemeanor obstruction. 2018 probation violation. 2018 marijuana conviction. Obstruction, no low, theft by receiving conviction from 2010. That's all.
Ms. Mitchell?
Yes, Your Honor. In the police report, it states that defendant battered Miss spelled Lanita, Pittman, spelled Pittman, by the face, causing swelling and lacerations to her left eye. It started with a dispute between Miss Pittman's daughter and the defendant's daughter, at which point the defendant went to confront Miss Pittman about her daughter's missing phone. According to Miss Pittman, that's when the defendant sucker punched her. There was also a witness who saw the defendant attack Miss Pittman while on top of her in front of their daughters. Your Honor, there is a current $4,500 surety bond on this case, and the state's going to request that that bond remain the same, along with a no further contact with Miss Pittman and her daughter, a stay away from address 1724 Leslie Avenue, Southwest, Atlanta, Georgia, a one-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, we're concerned.
It looks like we've lost contact with Ms. Mitchell.
Yes, Your Honor, I can pick up from where Miss Mitchell left off. With Bria Harris, let me just bring that up very
For no
quickly.
break.
Oh, I think we may have gotten her back.
You're going in and out on us, Ms. Mitchell. I don't know if you were just in a bad location.
Okay.
The last thing I heard you say is that we are concerned.
Okay, 1 second. Let me relocate. Okay, is that, hopefully this is better.
Yes, that's better. Thank you.
Okay, so we are concerned about defendant's risk of reoffending. The defendant does have an open case for simple battery against a law enforcement officer in 2021, where she was given a $1,500 signature bond. Our victim advocate also spoke with Ms. Pittman, and she stated that she went to the hospital. They were able to conduct a head CT because it looked like it would have been an orbital fracture based on the photos she was able to provide us. There were no breaks, but she was diagnosed with blunt head trauma and her eye was swollen shut. And again, based on the photos provided, it was a serious black eye. Ms. Pittman also stated that the defendant wore some sort of brass ring on her hand when attacking her. So based on this looking like an unprovoked attack and Ms. Pittman's severe injuries, that's going to be the basis of our recommendation, Your Honor.
Thank you, Ms. Gant.
Thank you, Your Honor. Ms. Bria Harris is 28 years old. She has been in Georgia long-term. She has 2 children, ages 11 and 4. She is not receiving any child support and she is the primary caretaker. We are unopposed to the stay away at 1724 Leslie Avenue. Ms. Harris completed high school. She works as a Lyft driver. Regarding the allegations, my client denies the allegations, Your Honor. She states that this incident arose from interactions between Ms. Pittman's children and Ms. Harris's daughter. She states that Ms. Pittman's 5th grade daughter and 8th grade son attacked her child and stole her cell phone. She went over to Ms. Pittman's house merely to ask about retrieving the telephone, which she paid over $300. She denied initiating any physical contact with Ms. Pittman. She states that Ms. Pittman pushed her and she was more so defending herself. Ms. Harris informed me that her shirts were torn and that she also sustained some bruises on her as well. There's nothing in the allegation or in the warrant that I read about any brass rings or knuckles or anything like that. Your Honor, based upon the competing versions, I am requesting a signature bond. I understand my client's prior history. However, that case is open. She is presumed innocent in that case, along with this case as well. It's also a different complaining witness. So we don't have what's established here as a continuing course of conduct. Your Honor, we are again unopposed to the stay away and the no contact orders. And again, I would ask for a signature bond. And Your Honor, if you determine that she's ineligible, then a bond of no more than $1,000. Thank you.
Okay. It's going to be a $2,000 good bond. No further contact with Ms. Pittman. Stay away from the Leslie Avenue address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Harris.
Thank you, Your Honor.
I'm sorry, Judge, can you repeat the bond again?
2,000 good.
Thank you.
So do we have anyone else? We're done with courtroom 3?
Yes, you can go to courtroom 2.
Okay, thank you.
Your Honor, just to let you know, it looks like the recording may have stopped. I just got a message that said recording stopped. Maybe it was on my end, but.
It's still saying live on YouTube on my
Okay.
end.
Thank you, Your Honor.
Ms. Lewis, if you can just verify that when you get a chance to make sure that it's still active. All right, who do we have in courtroom 2?
Position number 20, Ms. Moore.
Good afternoon, Ms. Moore. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Ms. Moore, you've been charged in case 22 CR 001228D, criminal trespass, obstruction of a law enforcement officer, and possession and use of drug-related objects. Is there a history, Mr. Howard?
Third arrest, 2013 domestic assault, 3rd degree. It was dismissed. And a 2016 driving out of Missouri.
Okay. Was she on the list?
Is this
Think so.
for Katisha Moore? Because I have something different.
We do have 2.
Jordana Moore. I thought we were doing Jordana. Oh, you know what? You're right. We are
Yeah.
doing Katisha. My bad. She got 6 total. Her last arrest was 2017 for solicitation. It was dismissed. 2014 FTA not prosecuted. 2014 probation violation out of Barrow County. Got a 2014 trespass conviction. Forgery and a 4th degree conviction. 2 counts from 2013.
Okay. Ms. Mitchell?
Yes. Your Honor, in this case, the defendant was criminally trespassing at Mikey's Beauty Supplies located on 2457 Martin Luther King Jr. Drive, Atlanta, Georgia. The defendant was issued a criminal trespass warning on March 1st to stay away from the property. Officer waited 5 minutes to give defendant a chance to leave, but the defendant refused. When the officer attempted to arrest the defendant, she started to resist by pulling away and refusing to put her hands behind her back. Once under arrest, a glass crack pipe was recovered from the defendant's front right pocket. The state's bond recommendation in this case is going to be a $1,500 surety bond, a stay away from the 2457 MLK address, and no alcohol, drugs, and weapons. In this case, the defendant is a convicted felon with a previous criminal trespass conviction. The defendant was also, being that the defendant was just issued a criminal trespass warning and returned back to the property, we are concerned about defendant's risk of reoffending. The defendant also has 1 failure to appear from 2014 and 1 probation violation in 2014 as well. Nothing further, Your Honor.
Thank you, Ms. Kim.
Yes, Your Honor. Ms. Moore is actually 35 years old, and her major concern is that she's residentially challenged right now. It has been years that she has been homeless, and that's the main reason that she has been continuously doing criminal trespass by no choice. She does not have a place to go right now. So we have prepared social worker services contact for her. And at the same time, she has not been able to gain any employment because of her disability. She gets seizures and she has been very sick. And she used to get a disability check. However, she was not able to maintain. So somebody has to kind of help her out with the paperwork as well. She's been here in Georgia for her life, 35 years. And she does not have a husband or other family members except one daughter. So we would like to request for signature bond since she has no way to pay any bond amount here at this point. Thank you, Your Honor.
All right, it's going to be $1,000 signature bond through the jail for each count, which makes it a total of a $3,000 signature bond through the jail. Stay away from 2457 MLK Drive, no drugs, alcohol, or weapons while out on bond. Let's see, Ms. Moore, I'm going to let you out, but you can't go back to that Mickey's. You understand?
Yes, sir.
Okay, good luck to you, ma'am.
Love you too.
Then we got number 6, Mr. Corinne. All right. How you doing, Your Honor?
I'm doing well, Mr. Corinne. Good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Corinne, you've been charged in case 22 CR 001090G with willful obstruction of a law enforcement officer and battery. Is there Ms. Falk, is there something?
Yes, Your Honor. This one took me a little by surprise because this has been a reset for about a week now. We will need a breakout. I anticipated he was a reset, did not realize he was here today.
So we also need breakouts for other cases that I'll do at the same time. I believe one.
Yes, Your Honor, I do have position number 22 for breakout as well, Your Honor.
Okay, that's what I was going through, Ms. Kim.
Yes.
So I have 1, 22, 23, and position 6. Is that correct?
Yes. Thank you, Your Honor.
And
Yes,
also, Judge, Ms. Klaus, she haven't spoken to her client, the other Moore on the counter, is it Jonana Moore? And she needs a breakout room for that person. I don't know what courtroom that person is in for her to call.
What position is that?
That would be position number 19.
Number 19. Courtroom 2, can you tell me where Jodana Moore is? She's position 19.
Give me 1 second, Your Honor.
Okay. And so.
What were the positions that you said you're going to need a breakout in again? You said 6, 22.
23 and 1. I'm going to handle those all in one breakout.
I just want to put the cards to the side.
Okay.
So we can go forward with the other positions. Let me see over here.
Yes, sir. Thank you, Your Honor.
So hold on though, but we're going to need breakout rooms, but I'm going to need to be in those breakout rooms. So
you're going to do the breakout for all?
Yeah, all at one time, so that hopefully that'll move things along. What I was hoping was that for Ms. Moore, if we can locate her, Ms. McLeod, that's her client, and she needs to speak with her. So if we can locate her, if she's going to be on the calendar, well, she is on the calendar, then
She should be in Union City, Your Honor. She's in Union City. Did you do Union City already?
Yes, we did Union City to begin with. So Ms. Lewis, what I need for you to do, if you would, is put me into the breakout room, and then once I'm in the breakout room, if you'll call Union City for me to see if they can get Ms. Scarborough.
Just
Moore.
South Annex is on.
Okay,
I need them to hear before they can go in a breakout room unless you just want to call the number out there. I can give her the number in the chat.
all right, so let's get back on track here. Who am I gonna need in the breakout room? Ms. Falk, I know. Ms. Kim, I know. Who else? Ms. Mitchell,
Ms. Gant, Your Honor.
Ms. Gant, thank you.
You too.
Mr. Segura. Okay, so Ms. Lewis, if you can put us all in a breakout room. Okay, courtroom 2. Let's see. We're back. So can we start? Do we have any deputies in courtroom 2?
Yeah, who you got? Who you want first?
Okay, let's go back to number 6 and we'll finish up with him. Mr. Curran, I've had a discussion with your attorney and the prosecutors while we were gone. The bond in your case is going to be $1,000 good bond for the willful obstruction, a $2,000 good bond for the battery. No further contact with Ms. Tedder. No drugs, alcohol, or weapons while out on bond, and a MHET. All right. So good luck to you, sir.
Thank you, Your Honor.
You're welcome. We also, courtroom 2, we also did position 1. Do we have Mr. Bates there?
What do you do here? Come on, Ms. Bates. Right.
Good afternoon, Mr. Bates. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Did you hear me, Mr. Bates?
I don't care. Sure,
Did you hear what I said?
I heard you.
Okay. Do you agree to have your case heard by video?
I don't care. It don't matter.
All right. So you've been charged, Mr. Bates, with
I will skip the button, go to something.
Okay, hold on, Mr. Bates. All right. In case 22 CR 001245E with criminal trespass and a second misdemeanor offense. Although we had a discussion about your case, it's going to be a $500 good bond for each of the offenses, a stay away from Georgia Tech, and a no drugs, alcohol, or weapons while out on bond. I am also reconsidering, and I think that a mental health evaluation is needed.
Your Honor.
Yes, Ms. Gibbons.
I don't recall. Is it on the court's own motion, or I do not recall that being a subject of discussion in the breakout?
Although it wasn't a subject of discussion, well, it was a subject of discussion because I think that's why we were there. But given Mr. Bates's demeanor, I think that might be helpful. Why don't we do this? Not an MHET, so why don't we have a social worker go and make an evaluation if he doesn't get it.
Okay, thank you, Your Honor. I will enter that.
All right, I appreciate it. All right, good luck to you, Mr. Bates.
I appreciate it.
Courtroom 2, we also discussed position number 22. Mr. Ritchie.
Here you go. How you doing, John?
Good afternoon, Mr. Ritchie. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. We are conducting this calendar by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Ritchie, you've been charged in case 22 CR 001263Y with 2 counts of simple assault. Your attorney had the opportunity, along with the solicitor, to speak on your behalf while we were in the breakout room. The bond for you will be a $2,000 good bond on each count, which makes it a total of a $4,000 good bond. No further contact with the alleged victims in the case, no drugs, alcohol, or weapons while out on bond, and a mental health evaluation. Good luck to you, Mr. Ritchie.
Appreciate it.
Okay, so courtroom 2, whomever you have next.
Number 5, Mr. Christmas.
Hello, Your Honor.
Hello, Mr. Christman. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Christman, you've been charged in case 22 CR 001248A with battery family violence. Is there a history, Mr. Howard?
First arrest.
All right, Mr. Segura.
The incident occurred on March 7, 2022 at 110 Cimarron, spelled Cimarron Parkway, Sandy Springs. In this incident, officers responded to a domestic violence call, and the victim, Blair Jackson, Blair spelled B-L-A-I-R, Jackson, common spelling, stated that the defendant punched her in the lip after an argument in an apartment that left her lip bleeding and swollen. Alongside, her inner right elbow and her knee had scrape marks because the defendant pushed her out of the apartment. As such, the state is recommending a $5,000 surety bond, a stay away for the incident location at 110 Cimarron Parkway, no further contact with Blair Jackson, 1-day anger awareness, and no alcohol, drugs, and weapons. Our recommendations are based on these facts, as well as because we have an intimidated witness. Ms. Jackson is the girlfriend of the defendant and both live together. And as we know, relationships tend to be complicated, and thus we're mostly concerned about our future, about the health of Ms. Jackson. Thank you.
Ms. Gant.
Thank you, Your Honor. Mr. Krishmer is 36 years old. He is a long-term Atlanta resident. He has family here, including his mother. Your Honor, we are opposed to the stay away at 110 Cinnamon Parkway or Kenneman Parkway. Mr. Krishner is the primary leaseholder there. However, Your Honor, I was unable to make contact with Ms. Blair Jackson. Mr. Krishner wants to continue having contact with her. However, again, I was unable to make contact with her, so I will defer to the court's ruling. Mr. Krishner completed high school. He is a few credits away from obtaining a degree in computer science. He is gainfully employed at the Georgia Library Services for the Blind. Your Honor, he states that despite being employed, he only has about $97 to his name. And I reached out to his mother, Susan Stone, to see if she may assist with bond. I was unable to reach her as well. And in light of the court's potential ruling that my client may have to stay away from that residence, and in light of his history of no prior convictions, I am requesting a signature bond, Your Honor. Mr. Krishner denies the allegations. He states that he was initially pushed by Ms. Blair Jackson. She initiated contact with him. She was actually throwing objects at him, and any actions were in self-defense. He states that they are scheduled to attend a joint counseling session on March 23rd so that they can continue to work on their relationship. And I would just ask that Your Honor consider this in terms of whether or not you initiate that no contact order. Thank you.
Okay. It's going to be a $2,000 signature bond through pretrial 1-day anger awareness class. Since no one has spoken with Ms. Jackson.
Sorry for interrupting. The victim is here in the courtroom as we speak.
Oh, okay. Well, thank you. No, that's, can you bring her forward?
Yes, sir.
Okay. Good afternoon, Ms. Jackson. I'm Judge Eric Morrow. It's my understanding that you would like to address the court before I issue the bond. So if you would like to do that, I'll need for you to raise your right hand for me. Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, and can you step forward a bit so you can put your hand down? Step forward a bit so I can hear you. All right, go ahead. What would you like to tell the court?
I would like to drop all charges. I was upset the other night, and this has happened before, and we've agreed to work on it. I didn't know that it was going to go this far, but I am not charging him with anything, and I do believe that we can work through this, and we have some steps in place to do so.
Okay, has this happened before?
Only one other time.
Are you afraid of Mr. Christmas?
No.
I've been told that you all have a counseling session coming up this month. Is that true?
Yes.
All right. Anything further that you'd like to tell the court?
No.
Okay. Thank you, Ms. Jackson. All right. So if Mr. Christopher can come back up when. All right. So it's going to be a $2,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with Leo Jackson, and no drugs, alcohol, weapons while out on bond. You're also to attend any counseling sessions that that you have scheduled. All right. Good luck to you, Mr. Christmas.
Thank you, Your Honor.
Thank you, Your Honor.
23, Mr. Russia.
Who do we have at the South Annex?
We have Ms. Moore, Your Honor.
And you're gonna need it. Have you already had your breakout room, Ms. McLeod?
I have, Your Honor.
Okay, I just wondered. Okay, so thank you. Okay, if you wouldn't mind, go ahead and unmute for me, South Annex, please.
South Annex is courtroom 2, Judge.
Okay. Good afternoon, Mr. Russian. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good afternoon. Yes, sir.
Okay, thank you, Mr. Russian. You've been charged in case 22 CR 001264F with battery. Is there a history, Mr. Howard?
39 total. Last arrest was August 2021, battery, simple battery out of Clayton County. That's open. Has an open possession of marijuana with intent out of Fulton. 20 CP 196048. On probation for entering auto and theft by taking 18 SC 157213. They gave him 4 years probation in August of 2018. 2021 disorderly conduct conviction. I got a freight from 2018 NOLO. 2014 battery conviction. What else? 2010 robbery, possession of a firearm by convicted felon conviction. Probation violations. Got a 2008 ag assault conviction.
Okay, thank you, Mr. Howard. Ms. Mitchell?
Yes, Your Honor, in this case, Your Honor, this was the breakout room session case. Would you like me to proceed on here?
Okay, I don't have position. Yes, I do. Okay, this is Ms. McLeod's case?
Yes.
Okay.
Yes, it is my case, Your Honor.
All right. Since you were not available, you couldn't go into the breakout room with us, Ms. McLeod. So let's go into the breakout room with Ms. Mitchell, Ms. McLeod, and Ms. Falk, please.
Okay, Judge.
Okay, courtroom 2, we've had a conversation about Mr. Russian with counsel in the breakout room. It is going to be a $4,000 good bond. Stay away from 1888 Peachtree Road. No further contact with Cassandra Smith. No drugs, alcohol, or weapons while out on bond, and a mental health evaluation. Good luck to you, Mr. Russian.
Heading back, or you want me to go back up?
You go sit this. We got number 9, position number 9, Mr. Isaac Garvin.
Okay.
Good afternoon.
Good afternoon, Mr. Garvin. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
I agree.
Thank you. Mr. Garvin, you've been charged in case 22 CR 001251D with public drunk and criminal trespass. Is there a history, Mr. Howard?
This 5th arrest, previous 4 come out of the state of Florida. 2018, possession of synthetic cannabinoid. It says community control, 3 years was the sentence. Before that was 2017, domestic violence, crimes against person, arrest. 2017, out of county hold, and a battery from 2017. It says community control, 3 years for that charge as well. So I'm assuming it's a conviction.
All right, anything further? Mr. Howard?
Oh, you're a resident of Florida, according to the booking sheet.
Ms. Falk?
Yes, Your Honor. This actually happened over at the BP gas station located at 3445 Webb Bridge Road in Alpharetta. Officers arrived there because there was an intoxicated person who refused to leave the premises. They met with the defendant. The defendant had not at that point been asked to leave the property. However, the BP gas station attendant indicated that once he had completed his transaction, the BP gas attendant then asked that he be removed from the property. When the officers were speaking with him, they did notice he had strong odor of intoxicants coming from his breath, as well as very slurred speech. They then took the defendant to remove him from the property. They detained him in handcuffs. At that point, the defendant demanded that the officer drive him to his hotel. The officer declined to do so. He then started arguing with the officer. The BP gas station asked that he actually be formally trespassed. When the officer then tried to formally trespass the defendant began urinating on himself and the officer's patrol car, again demanded a ride and started cursing at him and saying, "You're not serving and protecting, that's your effing job. I'm not getting out of this effing car," multiple times. This all happened while patrons are actually walking back and forth to the store and kind of watching what's happening, because this is all happening out in the open once the officer removed the defendant from his vehicle. At one point, a supervisor was brought to the scene. The defendant then tries to get in the supervisor's car and refuses to let the supervisor try to block the supervisor from getting into his own car. And so at that point, the officers had to drag him into a full caged car, because at that point, he then refused to get in the officer's car. They had to physically drag him into a caged vehicle to remove him from the location. So the state did add a charge of obstruction of an officer just because of just the craziness that was going on that day. We are asking for a $3,000 surety bond, $2,000 on the public drunk, $1,000 on the obstruction of an officer. Stay away order from that BP located at 3445 Webb Bridge Road in Alpharetta. We are also asking for no alcohol, drugs, and weapons. I would also ask for an ADET, Your Honor, just because not only does he have that 2018 cannabinoids conviction, but obviously he was very highly intoxicated on the date of this incident. And so we do have some concerns of some alcohol drug abuse here. The reason mainly for the $3,000 surety bond, Your Honor, is because of the defendant's lack of ties to this community. We also have his address being Miami Gardens, Florida. That is on the warrant. That is on the booking information. His record is out of Florida. I can't show where he has any ties to this community at this point, which is why we are asking for a $3,000 surety bond to ensure that he does reappear for court when necessary. That's all for the state.
On my calendar, Ms. Falk, I only have public drunk and criminal trespass. You're on mute.
My apologies. It was criminal trespass, not obstruction.
Okay.
But we did do a criminal trespass because he was asked to leave by the store. They wanted him formally trespassed. He refused to leave when they asked him to leave the store. And that's actually what led to the officer having to physically detain him.
Okay, thank you. Ms. Kim?
Yes, Your Honor. He is 31 years old. He came from Florida. He came to Georgia on November 2021 because he has a job. He's a cook at a Wild Wing restaurant. He has been working there from ever since November 20. He relocated to Georgia, and yet he does have a residential challenges. Actually, he is interested in the participating in a program for the housing. So I was going to recommend social worker services for him as well. He cannot pay for $3,000 surety bond at this point because the money that he's making as a cook at Wild Wing is not that much at this point. He cannot even have a permanent place yet. So we would like to request for signature bond for this. And he does not have a ties to the community. We do admit that part. And yet, because of his job, he does not want to go back to Florida at this point. Thank you, Your Honor.
All right, so it's public drunk and a criminal trespass. Mr. Garvin, it's going to be a $1,000 signature bond through the jail on each count, $2,000 signature bond through the jail. You're to stay away from that BP gas station, and you're to have no drugs, alcohol, or weapons while out on bond. Courtroom 2, if you'll unmute for me, please. Mr. Garvin, I'm going to give you the opportunity to get out, but you're going to have to show back up for your next hearing. Otherwise, they're going to put a warrant out for you. And you're not to have any drugs or alcohol. If they pick you up and you do have drugs or alcohol, you're going to be in violation of this bond. You understand what I'm saying?
Yes, sir.
All right. Good luck to you, Mr. Garvin.
Appreciate it.
Thank you, Your Honor.
Who do we have next?
We have position number 4, Mr. Bryan.
Good afternoon, Mr. Bryan. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Bryan, you've been charged in case 22 CR 001247H, reckless conduct, discharge of a firearm on the property of another, and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
6 total. January 2021, Texas, carrying a weapon. March 2021, Henry County, FTA for shoplifting, trespass, and obstruction. He was originally arrested for that August 2020. 2017, marijuana possession, dismissed. 2015, suspended license, dismissed. And he has a hold out of Henry County.
Okay. Mr. Fedora?
The date of offense happened in March 7th, 2022, at the location of the Law at Morgan Falls apartment, located at 415 Morgan Falls Road, Sandy Springs. In this incident, also responded to a call about a man shooting in the woods, which was caught on camera by a witness. The defendant was in the woods, 50 feet from the parking lot and 100 feet from the pool area, where he fired a handgun 10 to 15 shots. And then he placed the gun into his pocket and went back to his home unit in the apartment building. When the police arrived on the scene, the defendant came out and yelled at officers. When the police told him that they would pat him down to check for weapons, due to the video and the nature of the crime, he quickly began retreating back to his home. When police told him to stop, he refused. And when police told him to stop resisting, he still resisted. And when the police tried to put handcuffs on him, he wouldn't allow them until another officer came up to do so. As such, the state is recommending that the court retain that $7,500 surety bond, which was $2,500 for the first charge, $2,500 for the second one, and $2,500 for the willful obstruction. We're also recommending no alcohol, drugs, and weapons. Stay away from the Laura and Morgan Falls apartment at the incident location, and one-day anger awareness. Our recommendations are based on these facts, as well as previous history relating to possession, as the pre-trial noted. In 2001 in Texas for unlawful carrying, and one for possession in 2021. Thank you.
Ms. Gant?
Thank you, Your Honor. Mr. DeAndre Bryan is 23 years old. He has been in Atlanta for 13 years. He has family here, including cousins and siblings. He also is proud father of a 1-year-old son. Your Honor, we are opposed to the stay away at 415 Morgan Falls Road. That is Mr. Bryan's address. Mr. Bryan completed high school and he has been accepted into Stanford Law. He is scheduled to attend law school in the fall of 2023. He is self-employed in family businesses, including Air Excel LLC. Mr. Bryan denies the allegations. He states that he was in his apartment. He walked outside. He denies resisting arrest whatsoever. He was more so just trying to get an understanding as to why the police approached him. Furthermore, he denies firing the gun. And we heard the state mention his possession charge, which is of a different nature than this allegation here. And there are no allegations whatsoever that he was not permitted to be in possession of a firearm. I am requesting a signature bond on Mr. Bryan's behalf, and if Your Honor determines that he is ineligible, then a bond of no more than $2,500, and that would be $1,000 for the reckless conduct charge, $1,000 for discharging a firearm, and $500 for the willful obstruction of a law enforcement officer. Thank you.
Okay, then that's what it'll be, Ms. Gann. 1,000 for the reckless, 1,000 for the discharge, 500 for the willful obstruction, making for $2,500 good bond. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Bryan.
Thank you, Your Honor.
What was that total?
2,500.
That's a good bond, Your Honor?
That's correct, yes.
Next, we have position, I believe, is 16 and 17. Mr. Mahan, Jarvis.
Yes, I'm gonna defer to the state on the history. My coworker got it. He went to felony earlier, got a $5,000 good bond.
Okay. Good afternoon, Mr. Mahan. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Mahan, you've been charged in case 22 CR 001258A with simple battery family violence, and in case 22 CR 001259A with simple battery family violence. So, do you have a history, Ms. Mitchell?
Yes, Your Honor.
Okay, so give me that in your presentation, please.
Will do. So Your Honor, in this case so as to the position 16 for the simple battery family violence, on February 6th of 2022, the defendant battered his girlfriend he lives with, Miss Jasmine Bryant, common spelling, By pushing her onto the bed, Ms. Bryant is pregnant with the defendant's child when the defendant jumped on her. During a verbal dispute, the defendant pushed Ms. Bryant onto the bed and pinned her down. Ms. Bryant originally motioned that the defendant grabbed her around the neck, but later clarified the defendant didn't touch her neck. Ms. Bryant has had a TPO against the defendant for previous domestic violence incidents. Ms. Bryant informed the police that she plans to get a TPO reissued against the defendant. As to position 17, on January 16th of 2022, the defendant battered Ms. Bryant by pushing her, causing her to fall to the floor. The state's bond recommendation is going to be, as to count 1, a $3,000 surety bond, and as to count 2, a $3,000 surety bond, totaling a $6,000 surety bond. No further contact with Ms. Jasmine Bryant. A stay away from their address 443 Ponce de Leon Avenue, Northeast, Atlanta, Georgia. A one-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, in this case, we're concerned defendant's risk of reoffending. On March 6, 2022, the defendant was found pulling on the doorknob and trying to enter their apartment on 443 Ponce de Leon. That's when the defendant was arrested on these 2 warrants and picked up on 2 other drug charges, which I believe pre-trial stated he received a $5,000 good bond on. The defendant is also a convicted felon with a violent history. He has 21 cycles in Georgia. The defendant has a battery conviction in 2018, a battery family violence he pled NOLO to in 2009, and a robbery conviction in 2003. Ms. Bryant also stated that she's had to get a TPO on the defendant before for, again, domestic violence. We are concerned about witness intimidation in this case, being that they've been in a long relationship and Ms. Bryant is currently pregnant with the defendant's child. We're also concerned defendant being a flight risk, being that he has 7 FTAs and 20 probation violations. Nothing further, Your Honor.
Ms. Kim?
Yes, Your Honor, Mr. Mahan is 36 years old and they live together. Actually, Ms. Bryant she wanted to join us at the Zoom. I'm not sure if she's here. She is not scared of him. Actually, I was able to talk to her and she said that there was a lot of misunderstanding and she is definitely not scared of him. She wants Mr. Mahan to come back home as they're expecting a baby this coming June 2022. Only 3 months left and she needs a lot of support from her husband. I mean, not husband, but her child's father. And Mr. Mahan he has been here in Georgia for 36 years, all his life. And he has a mother and 3 sisters here in Georgia. And right now he's working at Papaya as a cook, and he would like to keep this job. So he started on June 12, 2021, after he was in jail for 28 months. Because of pandemic, his sentence was kind of like went out to the maximum. He was not able to get out of the jail for a long time. And because of his failure to do some kind of classes, which was not available to have during the pandemic period. So we would like to request for signature bond for those 2, since they're kind of like connected to each other, number 16 and 17, those battery charges. Thank you, Your Honor.
And Your Honor, the state would like to add, as to the defendant's history, that he was convicted for battery family violence against the same victim, Ms. Jasmine Bryant, case number 19CR006412F. Also, as to the aggravated battery, he deprived a man of his vision. So that's just to emphasize his violent history. Nothing further, Your Honor.
Thank you. It's going to be a $2,500 good bond for each charge, making it for a total of a $5,000 good bond. No further contact with Jasmine Bryant. Stay away from 443 Ponce de Leon Avenue. He can go back there on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, or weapons while out on All right, good luck to you, Mr. Mahan.
Thank you, Your Honor.
Who do we
Your
have
Honor,
next?
position 19.
Okay. Good afternoon, Ms. Moore. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Moore, you've been charged in case 22 CR 001261G with battery. Is there a history, Mr. Howard?
Yeah, so this is the one out of Missouri. Third arrest, last was 2016, a driving offense, and a 2013 domestic assault dismissed.
Okay. Ms. Mitchell?
You want to hang up on you? Your Honor, in this case, the defendant battered her roommate, Miss Rihanna, spelled Reyawna Brown, by grabbing her from behind, putting her in a chokehold, taking her to the ground, and then biting her, causing a laceration on her neck and finger. Their neighbor, Mr. Colton, witnessed and recorded the altercation on his cell phone, and the video shows the defendant being the primary aggressor. The state's bond recommendation as to this case is going to be a $3,000 signature bond, no further contact with Miss Reyawna Brown, a stay away from the address 410 Lake Dillon Court, Fairburn, Georgia, a one-day anger awareness course, and no alcohol, drugs, and weapons. And that's going to be due to her remote history. Nothing further, Your Honor.
Cloud?
Yes, Your Honor. My client, Miss Moore, she moved to the state of Georgia to engage in ministry, Your Honor. She is involved with the church a lot, she tells me. She also is involved in some other charitable work. She does have, I believe she told me, a nonprofit that she is working on. The situation is, Your Honor, when my client moved, she moved into what is called a pod split. It's a situation where you have a house and a number of people live there. They're unrelated, but it is sort of a low-income living arrangement. And this is the situation she's living with Rihanna. Rihanna is not someone that she knows. It's just these 8 people who pay a fairly low cost to live in this accommodation. She is trying to get out of that arrangement, but she's not in a position to do so right now based on her earning capacity, Your Honor. But they had a long history where Miss Brown, I believe her name is, had been picking on my client. And on this day in particular, she locked her out of the facility. She says, my client says that there are numerous reports of things that Miss Brown had done to her. Miss Brown kept trying to engage her, and because she would not engage in arguments with Miss Brown, she kept picking on her. And it's essentially what happened on the day she locked her out. And when she was trying to come back in, Miss Brown put herself behind the door to try to stop her from coming back in. And that was what happened. Your Honor, based on her history, I think she is a good candidate for a signature bond. Her last offense was a driving offense in 2016. She's 29 years old. She's not in a position to pay for a bond, Your Honor, based on my discussion with her.
All right, so the state's not requesting a good bond, so it's going to be a $3,000 signature bond. Through pretrial, one-day anger awareness, no further contact with Rihanna Brown. She's going to have to stay away from the 410 Lake Dillon, Georgia address. She can go back to that address on one occasion with law enforcement to retrieve any belongings that she may have there, no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Good luck to you, Ms. Moore. All right, thank you, South Annex. We appreciate it. Courtroom 2, who do we have next?
Position 18, Martin.
Good afternoon, Your Honor.
Good afternoon, Mr. Martin. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Martin, you've been charged in case 22 CR 0012660E with criminal trespass and damage to property. Is there a history, Mr. Howard?
15 total between New York and Georgia. Last arrest 2014, suspended license, hit and run. (2007) theft by conversion, 2 counts. It was NOD. Got a NOLO obstruction from 2007 out of Cobb. The last arrest in New York, I think, was in the 80s. Hold on. Yeah, 1989. That's it.
Ms. Mitchell?
Yes, Your Honor, in this case, on May 15th of 2021, the defendant damaged his ex-girlfriend, Miss Liza, spelled Liza, Jones, van by throwing a brick and breaking the rear glass window of said van. Ms. Jones drove to defendant's residence to drop off his clothes. That's when defendant got upset and threw a brick at the back of her van while she was leaving, breaking the window and causing damage in the amount of approximately $400. Your Honor, there's a current $2,500 surety bond on this case, and the state requests that that bond remain the same with no further contact with Ms. Liza Jones, a 1-day anger awareness, and no alcohol, drugs, and weapons. Nothing further, Your Honor.
Ms. Kim?
Yes, Your Honor, Mr. Martin is 61 years old. He does not live in the incident location, so there's no need for stay away. And of course, Miss Liza Jones have dated with Mr. Martin for about on and off 12 years. And when I spoke with her, she said that she was clear that, Mr. Martin is not a violent man, and this is kind of like a first incident. He has been here in Georgia from 2003. He's from New York, and he has established his life here as a apartment maintenance technician. He's been doing that for about 12 years, and he graduated from, he has a GED. He went to college, but he could not finish yet. And his charges are from they're very remote. We would like to request for signature bond, and we don't mind about no further contact as they broke up already. Thank you, Your Honor. Oh, I'm sorry. I totally didn't know that my video was off. Sorry.
That's all right. Ms. Jones, I see that you're on the line. You're not required to speak. If you want to speak and tell the court something, I'm happy to hear it. If you do, you'll have to raise your right hand for me and I'll have to swear you in, okay? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. What would you like to tell me, Ms. Jones?
Well, I just want him to be responsible for the damage to my vehicle because I've had to, wasn't able to get it fixed because of due to the loss of income from not working at that time. And at the time, my granddaughter and my goddaughter and another friend of mine was in the car when he did that. It could have hurt all of us, but I'm thank God it did not. And I just wanted him to get, be responsible for that, to pay for that damage to my vehicle.
Okay. Thank you, Ms. Jones. Anything further?
No, thank you.
All right. So it's going to be a $2,000 signature bond through the jail. No further contact with Ms. Jones, and stay away from Ms. Jones's residence. No drugs, alcohol, or weapons while out on bond. All right. Good luck to you, Ms. Jones and Mr. Martin.
Thank you, sir.
Thank you, Your Honor.
What do we have next?
Position 21, Pete.
Good afternoon, Mr. Peak. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have the case heard by video?
Yes, Your Honor.
Thank you. Mr. Peak, you've been charged in case 22 CR 0012662J with battery family violence. Is there a history, Mr. Howard?
19 total. December 2020, robbery by sudden snatch, simple assault. That's open. September 2020, egg stalking, open. 2018, aggravated assault, arrest. 2016, carrying weapon without a valid license. Possession of a firearm by convicted felon, those were convictions. 2012, entering auto, possession of a knife or a firearm during the commission. Those were convictions, as well as a robbery with that arrest conviction. It was amended from armed robbery. 2012, battery, 2 counts conviction. That's it. No, hold on. Possession of a sawed-off shotgun silencer conviction from 07. I think that's it. Yeah, that's it.
Mitchell?
Yes, Your Honor, on January 23rd of this year, the defendant battered the mother of his child, Miss Santricia, spelled Santricia, Cobb, common spelling, by punching her, causing her to fall and hit her head on the door jamb, causing a laceration and bruising to her forehead. It started with a verbal dispute when the defendant asked Ms. Cobb for her car keys. When she refused, he punched her. Your Honor, there is a current $20,000 surety bond on this case, and the state requests that that bond remain the same, and a no further contact with Ms. Santricia Cobb, third-party contact with her child, to stay away from address 1122 Northside Drive, Atlanta, Georgia. I'm not sure if that's the right address. I'm going to double check on that. But a one-day anger awareness, no alcohol, drugs, and weapons. The state concern here is defendant's risk of reoffending. He is a convicted felon with quite a violent history. The defendant currently has 4 open cases, as stated by pretrial. The defendant, and of those 4 open cases, include the robbery and simple assault in 2020 and 2 aggravated stalking cases, 1 in 2020 and 1 in 2018. The defendant was also convicted of 2 battery charges in 2012, robbery in 2013, and has 4 gun-related convictions. In the open aggravated stalking case from 2020, he was given a $10,000 signature bond, which was converted to a $2,500 surety bond. And in the open aggravated stalking case from 2018, he was given a $10,000 signature bond. The defendant also has a failure to appear in 2017 and 4 probation violations. So that's going to be the basis of our recommendation, Your Honor.
Ms. McLeod?
Yes, Your Honor. My client and the alleged victim have been in a relationship for several years. They actually share 3 minor children, Your Honor, a 3-year-old, an almost 2-year-old, and an 8-month-old. My client tells me that the alleged victim had gotten quite drunk on the date of the incident. She was drunk and she started throwing things and tried to attack him, and he asked her to leave the house. That was the basis of their argument. He denies that he hit her, Your Honor. He said he just asked her to leave the house. Right now, they're still co-parenting these 3 children, and the grandparents, his mother and her mother, have been the facilitators. He still does want to see the children, Your Honor, because they are important to him. But he doesn't mind having a stay away with respect to the alleged victim, because he tells me that they are no longer in a relationship, but he does want to maintain his relationship with the children. Your Honor, I know he does have an extensive record, but he tells me that he is currently gainfully employed, so he can take care of his children. He works at the Duracell factory in Fairburn. So I would ask the court to consider giving him a signature bond, and if that is not possible, of course, as low a bond as possible, because his resources are limited and he does have 3 minor children that he has to support.
Okay, it's going to be a $5,000 good bond, no further contact with Ms. Cobb, stay away from the 1122 Northside Drive address, third-party transfer for child visitation, and no drugs, alcohol, or weapons while out on bond. Good luck to you,
Thank
Mr.
you.
You're on mute, courtroom 2.
Your Honor, we have position number 24, last one, Mr. Scarborough.
Good afternoon, Your Honor.
Good afternoon, Mr. Scarborough. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Scarborough, you have been charged in case 22 CR 001266C with battery substantial physical harm. Is there a history, Mr. Howard?
13 total. Last was October 2020, probation violation. That was out of Florida. What else we have? Yeah. I saw a burglary, assault and battery conviction from, that was 2003. Yeah, all of his history come out of Florida. This is the first Georgia arrest. I think this was the SOB jail recommendation, right?
That's correct.
Yeah.
All right. Ms. Falk?
Yes, Your Honor. This happened back on August 26, 2021. Essentially what happened in this case is Timothy Tyler O'Dillon, Timothy common spelling O'Dillon, O''Dillon. Mr. O'Dillon was actually working in a construction zone. He is a construction worker. He was flagging individuals through a construction zone when he observed a gray Chevy Silverado approaching him southbound on Bumbalo Road. He stated that he waved at the driver to stop, but the driver failed to stop and continued to drive toward him. The defendant then abruptly stopped at the sign. Mr. O'Dillon admitted he exchanged words with the defendant, but at one point the defendant.
Mr. Scarborough, hold on. You have a right to remain silent. Anything that you say will be used against you, okay? Let's not have any outbursts. That doesn't look good towards your case. All right, go ahead. I'm sorry, Ms. Falk.
Thank you, Your Honor. The defendant then got out of his vehicle and slapped Mr. O'Dillon forcibly with an open hand on the left side of his face. There was a handprint. When the officers arrived, they actually were able to see a handprint on Mr. O'Dillon's face, as well as substantial redness to his cheek, cheekbone, and ear. This actually was a coworker who was at the scene, actually witnessed the event. He stated he did see the defendant get out of the vehicle and forcibly slap Mr. O'Dillon in the face. He actually also pictures were taken not only of the tag of the vehicle, but of the defendant, his appearance and what he was wearing at the time before he was then got in the vehicle and left. Officers were able to pull the information from the license plate, which then matched a motor vehicle collision, which happened on May of 2021 involving the same vehicle. They were then given a description of the male involved in the assault. They compared it with the photograph from his driver's license information and the photos that were given to the police by O'Dillon, and they were able to match those as the same individual, which led to the arrest of this defendant. Apparently, he has a very large distinctive neck tattoo, as well as a slim mustache, which allowed the police to identify him successfully. The state's recommendation on this case is going to be a $2,000 surety bond, no further contact with Timothy O'Dillon. There's not going to be a stay away because it happened in a construction zone area about a year ago. But the state's main concern is the fact that the defendant's history is mainly out of Florida. He does have some incidents of violence. I believe pretrial stated there was a previous robbery case arrest in there. And so we do have some concerns with the number of cycles in Florida and the fact that his history is completely out of Florida, that he may not have sufficient ties with this community. And therefore we are asking for a $2,000 surety bond.
Thank you, Ms. Moore. Ms. Kim?
Yes, Mr. Booker is 44 years old, and actually he does have ties to the community. They moved from Miami, Florida this October 2020 because he has a job here in Georgia as a truck driver. Not only that, he has a son who is 6 months old, and also he's married and his wife is here in Georgia as well. He has a family here, he has a job here. He does not want to run away from this area. And he's kind of wondering how they pointed him out as the defendant, because, the photographs, it could be slightly different. So he's denying the allegation completely. And all those charges from Florida happened very long time ago. So we would like to request for signature bond, Your Honor. Thank you.
All right, so it's going to be a $5,000 signature bond through the jail. Stay away from no further contact with Mr. O'Dillon. No drugs, alcohol, or weapons while out on bond. Good luck.
Thank you, Your Honor.
All right, courtroom 2. We also have position 15 in April Jones. Do you know what's happened with Ms. Jones?
Say that one more time, Your Honor.
We have a position 15, April Jones.
She's at Grady, yeah.
Okay, and we also have a waiver of the presence of position 3, Shannon Bebco. So I think you all might need to stay on the line while we take care of Ms. Bebco, so that if she's there, you'll know what the bond is, okay?
Okay.
All right, so position 3, Ms. Bebco. Is this your case, Ms. Falk? Mr. Segura?
No, it is Mr. Segura's. Just to let Mr. Segura know before he gets started, essentially the defense has waived Ms. Bebco's presence, but are going to just argue bond. So it's just a standard bond hearing at this point.
So you can proceed, Mr. Segura.
Okay, the incident occurred on March 3rd, 2022 at the incident location at 5925 Roswell Road, Sandy Springs. In this incident, the victim, Cannon Gilbreath, Cannon spelled K-A-L-E-N, Gilbreath, G-I-L-B-R-E-A-T-H, picked up the defendant in his vehicle from a Lowe's parking lot and took her to the incident location. At the incident location, the defendant had a bottle of wine and sat on the driver's seat, discussing that they can be drinking later on. At that point, both Mr. Gilbreath and the defendant got into an argument because the defendant was on a phone call with an ex-boyfriend. At this point, the argument ensued, and the defendant became animated and swung the bottle at Mr. Gilbreath's forehead right above his right eyebrow, which ended up causing a large sword contusion above his right eyebrow. As such, the state we are asking a $5,000 surety bond, 1-day anger awareness, no alcohol, drugs, and weapons. Stay away from Mr. Gilbert's home, which is located at 630 Hopewell Downs Drive, Milton, Georgia, and no further contact with Mr. Gilbert. The basis of these recommendations are on these facts, as well as because, as we can see, that in September 2016, the defendant was arrested for simple battery against a police officer. So this shows that she has a violent history. Also, because of intimidated witness, Mr. Gilbert is actually engaged to the defendant, and they used to live together at each other's parents' homes in the past. Thank you.
I'm sorry, Mr. Howard. Is there any other history? Do you know? Okay, all right. Let's see, Ms. Gant, I'll give Mr. Howard a moment to get back to his desk.
Right, thank you, Your Honor. Miss Bepko is 28 years old. She has been in the Atlanta area her entire life. She also has family here. We are unopposed to the stay away at 5925 Roswell Road. Miss Bepko has an alternate address. Further, she does not want any contact with Mr. Kaylin Galbraith. Ms. Bepko completed high school. She also has a bachelor's in aesthetics. At this time, Your Honor, she is unemployed and has been so for the past 3 months. Therefore, she does not really have the means to make bond. She denies the allegation. She states that Mr. Galbraith fell out of bed that morning and that is how he sustained that cut to the face. And in the warrant, Your Honor, it reads that Mr. Galbraith stated that he made a mistake calling the police and that he did not believe that she meant to hit him. For these reasons, Your Honor, I am requesting a signature bond on Ms. Bepko's behalf. Again, we are unopposed to the stay away and the no contact orders. And if Your Honor determines that she's ineligible for a signature bond, then the lowest bond possible, as again, she is unable to pay any bond at this time. Thank you.
Okay, thank you, Ms. Gant. Mr. Howard?
6 total. She got 3 DUI convictions in her history. 2016 simple battery DV conviction.
That's it?
Yes.
Thank you. $3,000 signature bond through the jail. No further contact with Mr. Gilbreth. Stay away from the Roswell Road address. No drugs, alcohol, or weapons while out on bond.
Your Honor, may we also have a one-time law enforcement to retrieve her belongings?
Yes.
Thank you.
Okay. Anything else, Ms. Gant?
Nothing further, Your Honor.
Okay, all right. And I think that completes the calendar. I've got Ms. Bridgewater in the courtroom with me, and as soon as she's ready, we'll go over the calendar.
Your Honor, my client, Miss Moore, has an issue which we would crave the court's indulgence just to clarify.
Okay, what position is Ms. Moore again, please?
I think she's number.
Oh, here she is, 19.
Number 19.
Yes.
Okay, so what is the issue?
The issue is, Your Honor, that the court said that she had to stay away from the location. She has told me that in the interim, she has contacted Pod Split, and they have told her that there is a likelihood that the other lady may be asked to leave. And she was wondering if she would be able to stay there if that person was leaving.
If the person is gone, she can go back. So, but if Ms. Brown is still at 410 Lake Dillon, then she necessarily can't go back. So I'll allow her to go back with law enforcement to see if Ms. Brown is still there. If Ms. Brown is there, then she'll just have to retrieve her belongings and find someplace else to stay. If Ms. Brown is not, if Ms. Brown is not there, then she can reside there if they allow her.
Thank you, Your Honor.
Okay, does that clarify it?
Yes, it does, Your Honor. Thank you.
You're welcome. Good luck to you, Ms. Moore.
Thank you, Your Honor.
Okay, thank you. We appreciate it.
Bye. Appreciate you.
Okay, again, the reset date for SAP is going to be March the 22nd. Position number 1 is reset to the SAP calendar with a $1,000 good bond. Position 2 is reset further notice with a $2,000 SOB through pretrial. Position 3 is reset further notice with a $3,000 SOB through the jail. Position 4 is reset to the SAP calendar with a total $2,500 good bond. Position 5 is reset further notice with a $2,000 SOB through pretrial. Position 6 is reset to the SAP calendar with a $3,000 total good bond. Position 7 reset further notice with a $2,000 SOB through pretrial. Position 8 is reset further notice with a $2,000 SOB through pretrial. Position 9 is reset further notice with a $2,000 total SOB through the jail. Position 10 is reset further notice with a $2,000 SOB through pretrial. Position 11 is reset to the SAP calendar with a $5,000 total good bond. Position 12, reset further notice with a $3,000 SOB through pretrial. Position 13 is reset further notice with a $1,000 SOB through pretrial. Position 14 is reset to the SAP calendar with a $2,000 good bond. Position 15 is being reset till tomorrow. Position 16 and 17 are being reset to the SAP calendar, and they each have a $2,500 good bond. Position 18 is reset further notice with a $2,000 SOB through the jail. Position 19, I'll come back to that one. $3,000 bond through pretrial, reset further notice. Okay, position 20 is reset further notice with a $3,000 total SOB through the jail. Position 21, $5,000 total good bond. I'm guessing on these, you guys. If you have something different, let me know at the end. I was trying to keep up. 22 is reset to the SAP calendar with a $4,000 total good bond. Position 23 is reset to the SAP calendar with a $4,000 good bond. Position 24 is reset further notice with a $5,000 SOB through the jail. And position 25 is reset further notice with a $3,000 total SOB through pretrial. Now, I know there were a couple of them that I stumbled on. Were those amounts correct, or do you all have any comments, corrections, or otherwise?
All right, so thank you all. I appreciate it, and we'll see you next time unless somebody has something else that we need to do today.